Good morning. Welcome to episode 2 of Brief Insights. So you think you have a right to trial by jury, right? It's guaranteed by the Constitution, isn't it? Maybe, maybe not. Today we're going to discuss something that applies to all of us, whether you own a small business or not. Today's discussion, we're going to talk about alternative dispute resolution, which is one way that you may have, whether you know it or not, you may have waived your right to have a trial by jury. So you've probably heard of alternative dispute resolution. We call it ADR for short. But what is it? What does it mean, and how does it apply to you? Well, you're probably already a party to one of these agreements if you've ever purchased anything off of Amazon or if you have a credit card. Chances are those came with terms and conditions that included an alternative dispute resolution clause, which means you agreed to go mediate or arbitrate your dispute rather than take it to court. So mediation, arbitration, these are the two forms of ADR, but they're very different. You need to understand those differences. Mediation is the simplest, easiest, friendliest form of ADR. It is basically a negotiation between the two parties. Two parties get together, they give an opening statement, and then a third party, neutral party, goes between the two. He sees the evidence, hears the evidence, and in the end he makes a recommendation to the parties. He gets to see both sides, and in the end he knows kind of what your strengths and your weaknesses are, and usually their recommendations are pretty solid. They'll recommend a settlement and a settlement amount, and some other terms if necessary. Now, the mediator may or may not be an attorney. Sometimes insurance industry professionals often go into mediation because they're so used to negotiating those claims. It doesn't have to be an attorney, just a really helpful, thoughtful third party. Now, if you don't reach a settlement in mediation, then you're free to take it to trial. You can agree with the third party's suggestion or not. You can take it or leave it. You continue to negotiate. There's nothing binding about mediation. Arbitration is the opposite of that. So arbitration, rather than having one neutral third party, actually has a panel of 1 to sometimes 3 judges of sorts that hear your case. Now these, most of the time, are licensed attorneys within the state. And you will have 1 to 3 of them depending on how your clause reads. This is kind of like a mini trial. Both parties get to do an opening statement. They present their evidence to the arbitrators, to the panel, and the panel makes a decision. Who wins, who loses, and how much are the damages? This may be binding or may not be. It all depends on how your clause reads. Now, if it's non-binding arbitration, that means you can take the judgment of that panel, and you don't like what they said, you don't agree with their judgment, you can still file suit. You can take it to district court and say, we tried arbitration, it didn't work. If you've agreed to binding arbitration, you're stuck. The decision of those arbitrators is final and binding on you. No court will overturn it. It is not appealable. So whatever they say goes. It can really affect your rights and restrict how you're able to recover in the case of a claim. Now, with Amazon, with your credit card companies, you don't often have a lot of choice. I understand that. But in day-to-day contracts that affect you and your business, you do have a choice. You need to make sure that you're protecting your right to trial by jury that the Constitution gives you. Thank you for tuning in. I hope you learned something, and I hope to see you next week. Have a great day.